The Court of Appeals for the State of Kansas is now in session. The Honorable Stephen D. Hill presiding.
Please be seated.
Just scanning the crowd here.
It looks totally different in here since the
It
remodeling.
does, since the bar has been put up and
Yeah. Looks like a courtroom now.
yeah.
Good morning, everybody. This is the May panel of the Kansas Court of Appeals sitting in Topeka. My name is Steve Hill. It's my honor and privilege to be the presiding judge on this panel. My longtime colleague and great friend joins me, Karen Arnoldberger. She is distinguished because she recognized that it's a lot more fun to just be a judge than being the chief judge.
Yes.
So she has wisely confined her duties and withdrawn from that, and she's enjoying a good time and going back to work. Now, one of our newest member is Andrea Purvis, seated to my left. She is a judge from the 6th Judicial District, which is very near and dear to me because that's where I had my beginnings, Bourbon, Lynn, and Miami County. And so we'll be talking about old times with her. It is, we will be taking up the cases in the order in which they appear on the docket. Counsel, we've read your briefs and we've received a pre-hearing memorandum from our research staff concerning each particular case. Each side having 15 minutes is not very long. So my suggestion to you is just get right into the heart of your argument. And but we might have a few questions for you as you proceed. If you have any rebuttal time and wish to reserve that, let me know. Let me know your appearances because I have to keep track of that. And when we get started on this is the one thing in the new courtroom that I don't particularly care for. I used to use my phone, and when you heard the sound of the ducks, your time was up. Well, this thing, it gets fine until the last minute and then those seconds. So try to ignore it because I find that quite disconcerting.
The old one we had, if you push the wrong button, would flash fire.
Yeah.
That was always fun.
That was exciting. So.
And we often pushed the wrong button.
So they have taken that button away from us.
Yes.
We have a highly skilled staff that is in charge of the button. All right. First case is 127221. Littell and Cherry Ryder, co-trustees of the Opal Little Family Trust. Bonnie Bielman versus Oxy USA Incorporated, an appeal from Stevens County. Counsel?
Your Honor, on behalf of the appellants, David Seeley, Ryan Meyer, and Emily Arita, representing the movements.
And who will be arguing the case?
I voted on.
All right, and that is?
David Seeley.
Thank you. And for the appellee?
Your Honor, my name is Dan McClure. I'll be arguing the matter, and with me is Jonathan Slattery.
Okay, thank you. Do you wish to reserve time for rebuttal?
I would like to preserve 3 minutes, Your Honor.
You got it. Yeah, let's turn the phones off. Let's not have that in again, okay? Thank you. All right. Proceed, counsel.
Good morning. May it please the court. I'm David Seeley. I represent the movements in this matter. And it's my privilege to represent the class in the Opal Littell versus Oxy lawsuit. We're here today because of Merit's deliberate and undisclosed repudiation of the uniform limits on deductions from royalty payments for natural gas that were contained in the 2008 judgment in this class action.
Let me ask you a question about that, if I may.
Sure.
Isn't there some argument in the briefs that that's really not a judgment? That was just a consent, a contract that the parties entered into that time, and then that was approved by the district court? Is that some way not a judgment?
No, Your Honor, it is not, because it is attached to, incorporated in, referenced, and relied on and approved and reviewed by the court. In fact, it could not go into effect without the court's approval,
Why is that?
because this is a class action under KSA 60-223. And there are thousands of absent class members who were not able to even attend the trial of this matter, who are affected by that settlement agreement because the court has ordered that it is valid and enforceable.
So the district court in its ruling has wiped all of that out, correct?
That's correct, Your
It's
Honor.
nothing.
Well, now, the agreement is still there, but the judgment
Is unenforceable?
is unenforceable. That's correct.
That's rather shocking. Then do the people no longer get gas payments?
No, because the leases remain in effect, Your Honor. They still get a monthly, they're still entitled under their lease
Under what
contract.
terms?
I'm sorry?
Under what terms?
Under terms that are set forth in the lease as modified by the ruling in.
It's not according to the judgment? So they're not complying with the
Well,
judgment?
it is according to the judgment. It is applied in accordance with the judgment. I guess you're right, that all that goes up in flames if the judgment is truly dormant.
Counsel, way back when Moby Dick was a minnow, I started my career. I practiced law in the country and we did a lot of quiet title actions. And I quieted title all through Bourbon, Lynn, and Miami counties. Those judgments are well over 7 years old now. Are those now meaningless?
Not under our view, Your Honor. I believe under the district court's view that dormancy applies to every judgment and any kind of judgment, which is not what the statute says.
Pretty broad terms in the court's order.
Yet very broad, Your Honor, very broad.
So now all those ancients, why should we bother to record judgments then?
That's a fair question. I had the same question. Why are judgments filed? What is their effect? When does their effect end? It ends according to their terms. And in this case, the terms of the leases, the royalty payment obligation, and the modified payment prohibiting deductions for fuel and deductions in excess of 15 cents per MMBTU for gathering continue in effect.
Proceed with the rest of your.
Okay, thank you.
I'm still
All right.
working through that.
Your Honor, I wanted to thank Merit for drawing court's attention to last week's decision from the 10th Circuit in our interlocutory appeal in the federal lawsuit, which holds that a plaintiff class can and should be certified in that case, and instructing the district court, the federal district court, to do so. This court may be interested to know that the 10th Circuit yesterday granted Merit's unopposed motion for an extension of time to file their motion for rehearing en banc, so the matter is still far from over. Just to be clear, we were forced to file that action in federal court after the district court in Stevens County ruled that the judgment was dormant and unextinguished and unenforceable. And so,
Well, quite frankly, that district court order is more profound than just this case, isn't it?
I think so, Your Honor. It sets a very dangerous precedent, and it's particularly dangerous to those of us who've practiced class action litigation, because no one has ever before suggested that a class action, a court-approved class action settlement is not binding as part of the judgment.
Let me ask you this. What's your concept of dormancy?
Okay.
Of judgment dormancy, because the statute speaks of that.
Yes, the statute does speak to it, Your Honor. Our concept of dormancy is that, as the statute says, if someone who has the ability to execute on a judgment fails to do so for a period of 5 years or does not file a removal affidavit sworn under oath stating the amount that is due and owing, the specific amount, then that judgment can become dormant. But other dormants that are not susceptible to execution as defined in the statutes are not affected. They are outside the scope of the statutory scheme.
Is it, we use language that the judgment becomes dormant, but basically you're talking about enforcement of that judgment, aren't you?
Well, it is. Yes,
Your means of enforcing the judgment become dormant?
no,
If so, isn't that the same?
it is not the same, Your Honor.
Explain it.
Well, there are several reasons. One, because the trigger is the executability. If you don't have the ability to execute, and that's what the statute says, then the condition, the trigger, the condition precedent is not met and the statute should not apply. And if the second consideration then becomes, how do you avoid your judgment becoming dormant? Well, you have to file a renewal affidavit, and that renewal affidavit requires that it be signed by the judgment creditor or their lawyer stating the remaining balance due and unpaid on the judgment.
Are you a creditor? You people you represent, are you a creditor?
Not yet, Your Honor, but we hope to be someday.
Okay.
We have unliquidated claims, we believe, against Merit for its de-implementation of the Littell settlement, if you will. It consciously decided to not honor that agreement.
Well, people break contracts all the time. The question I have is, how often do you get paid?
Monthly. The royalty owners get paid each and every month.
So is that a judgment every month?
Effectively going, well, it is if you treat the judgment here as being within the scope of the dormancy statute, then we would argue that as each recurring payment.
So you got 7 + 2 years
Right,
for each month.
right.
Are there cases to that effect?
There are, Your Honor. And I believe we've cited the case of Marriage v. Strom and Wichita Federal Savings. The next point I'd like to make, Your Honor.
Is there a statute that says that it basically refreshes every payment?
The statute doesn't say that, but the case laws under the dormancy statute have said that.
Mhm.
And the next,
Because it makes me think of, the Lilly Ledbetter Act. The whole point of that Equal Pay Act was so that she could bring suit after each bad pay, but that required statutory change. So that's why I'm asking.
well, what we would do, Your Honor, is what we did in the Littell case, which was bring a lawsuit, say you've underpaid our royalties. We get a judgment that makes us whole for the past and sets the framework for the future, prohibiting those type of deductions.
Mhm.
And that's what we would hope would happen here under the contempt power of the district court. Not execution of a judgment, but enforcement of a judgment under the contempt power, which is not addressed in the dormancy statute. The other reason.
And was this brought as a contempt act? Was that one of your claims?
We filed a motion to enforce and the district court construed it
Okay,
as
yeah.
a motion for indirect contempt.
Mhm.
And the other piece of the next piece of the dormancy statute is reviver. And so with renewal, you can't get a renewal unless you have a specific amount and you have a judgment creditor, which we don't have. In fact, we can't even determine what amounts they owe us because they can't calculate them based on looking at the check stubs. I would encourage this court to look at at least one of those check stubs and see if you can figure out what they're deducting for and whether, how much they're deducting in MMBTUs, not in the MCFs that are shown on their check stubs. And so the last piece of or the next piece of the statutory scheme is the reviver provision, which is in 60-2404, which holds that which provides a dormant judgment can be revived only if the holder of the judgment files a motion for reviver and a conditional request for immediate execution in the event that the motion is granted. Then at the motion hearing, the court shall enter an order of reviver unless good cause to the contrary be shown. And thereupon execution shall issue forthwith. So here we have something that we think they owe us. It's not been liquidated. It's unknown. We can't figure it out from looking at the check stubs. And yet the court held that that was eliminated by the dormancy provision, even though we had no ability to renew the judgment nor to revive the judgment, because immediate execution is a part of that process. So here, an execution is only possible when an amount can be stated. The standard writ requires the conclusion of the amount. No clerk is going to issue a writ of execution and no judge is going to sign it unless there's an amount stated there. You can't say, give me an order that says if merit violates the terms of the judgment in this case, then I win. You can't go, that's not execution. You can't enforce an injunction or a prohibition until it's been violated. That's the essential difference here. This judgment can certainly be enforced, and that's what we're attempting to do, but it cannot be executed upon. It cannot be executed upon. I'll stop there. And
I'm going to ask you a question because I didn't want to take up your time to ask you the question. So I'm doing it this way because it's just my lack of understanding, I guess, of class action lawsuits. So just as a education to me. So if once these people that are getting the royalty payments, say one person figures out that they're getting shorted, then do they have to go, it's only the class as a whole that can an individual?
an individual could do what we have done, which is file a motion.
But you did it as the class.
For the whole class.
Okay.
That's what we're attempting to do. But part of the problem with that is, even if I could figure out on my client's royalty check what the numbers were, how do I do that for thousands of people in the class? How do I issue a writ of
to say how much is due
because
total?
You owe me X number of dollars when I can't figure that out for even one person.
But one person could come in to try to enforce.
They could if they knew.
If they could figure it out.
Yeah.
But okay. All right. Thank you.
Okay. Hold on just a sec till we get the time right. There we go.
Thank you, Your Honors. My name is Dan McClure. I'm here from Merit Energy. They're not actually a party to the judgment that they're seeking to enforce. Oxy is not a party to this matter, believe it or not, even though they're the party who's involved. This case is really the perfect case, I think, for the application of the dormant judgment statute. Here's a judge.
Explain that to me, please, because I'm trying to figure out what has become dormant.
Oh, well, they're trying to misuse the judgment and a motion to enforce the judgment. All the judgment really did was approve a class action settlement for something like $18 million. And because Rule 23-223 requires a court in a class action to merely approve a settlement. That's all it did. They're trying to read the judgment as an injunction.
Now, don't be too quick there, counsel.
Okay,
When I hear the term a court approving a settlement,
yes.
that sounds pretty close to being a judgment to me.
Well, it is a judgment. It is a
And
judgment.
what is the nature of that judgment?
Well, one of the things the judgment did was to dismiss all of the claims that were then pending, okay? And basically end the lawsuit. They're suggesting, though, that injunction, that judgment is somehow an injunction because there's a separate settlement agreement It's an agreement between the parties.
Does
It is
that,
not incorporated into that judgment.
does that judgment not affect, have an in rem effect?
No, I don't think so.
And explain that to me.
Well, because it just doesn't. It's an agreement between parties. It's a judgment as to parties. You know, there's not any judgment as to real estate or oil and gas leases. Those are unaffected. Because you were asking earlier, well, doing away with the judgment means they can't enforce anything. No, they all have oil and gas leases in effect, unaffected by the judgment. Those leases require monthly royalty payments.
So the only in rem remedy any of these people would have in making this claim would be under the lease.
Well, under the lease, or in this case, to sue for breach of the settlement agreement. You got the judgment here, and then you've got the settlement agreement between the parties. They can sue for the breach of the settlement agreement, which provided in this case for some future limitations on the amount of deductions from royalties for gathering costs and the like. They are suing in federal court in the Ryder case for breach of the settlement agreement. And that's the proper way for them to proceed, not to try to enforce a judgment that did not incorporate that settlement and did not order that that future provision become effective. They have a complete remedy through this action for breach of settlement agreement.
Can you stop for just a second? And this is addressed to both of you. It occurs to me that I would ask that both of you submit to the panel some status of what's going on in federal court. You mentioned it and you're aware, and I want to hear from both sides on
Sure. Well,
what the status of all of that is.
what I filed last week was a copy of this 10th Circuit opinion that in an interlocutory appeal approved and ordered a class action in the suit that they're bringing for breach of the settlement agreement, which is a breach of contract suit. They have an utter and complete relief available to them and to that class that they now have, the 10th Circuit has now ordered they can have. They don't need to try to get into this judgment issue in trying to apply the judgment as if the judgment incorporated the settlement agreement. All it did was, quote, approve it, okay? And then the parties are left to their own devices in the future. And that device that they are litigating, and appropriately so, is for breach of contract. Now, we don't think Merritt, who bought the properties from Oxy, was subject to those future royalty provisions, but that goes to the merits. That's because of the way the agreement was read.
It's not really pertinent to.
No, it's not. That goes to the merits of whether Merritt is really
But the
bound by
settlement agreement was not a judgment.
No,
It's just a settlement. So
that's right.
what's the dormancy issue?
Well, they're
Can't be
trying,
dormant if it's
they
not
are
a judgment.
they are trying to use the judgment as if it incorporates all of the settlement terms and makes the settlement agreement a judgment. I think it's a misuse of it, but when you look at what they're really trying to do here,
So your issue is they failed to state a claim,
well, that's part of it. That's part of it.
but is that what the court said?
Well, no, that's because the court hasn't
Court
reached.
said it was dormant.
The court hasn't reached that issue. They just said that it's dormant because the judgment was never, no action was taken for 15 years to do
But you're
it.
saying there was never a judgment.
Well, yeah, there was a judgment. The settlement agreement terms are not part of that
Right.
judgment. And that's why we think they've inappropriately used this vehicle. When you look at the motion to enforce they filed, they're trying to leap over all the issues that you would have to get to enforce a settlement agreement. File a complaint, have an answer, have discovery, have a class certification, have a trial on the merits, and then they get a judgment for breach of the settlement agreement.
Okay, so did you argue before the district court judge that this was a dormant judgment?
It was the Judge Ambrosia's initial sua sponte order that this was dormant when he saw how old it
And
was.
you agreed with that? I mean,
We didn't
did you?
disagree with it.
Well,
And
if you didn't disagree with it, then aren't you acquiescing in the fact that it was a judgment?
yeah, oh, there's no question a judgment was entered. That judgment has become dormant, particularly when you consider what they're trying to use the judgment for, to imply that it incorporates the body of the settlement agreement. And you look at their motion to enforce, all they're going to do is bring Merritt in a single hearing, to enforce the settlement agreement. I'm sorry, to enforce the judgment. They're going to in a single hearing and say, you're liable and there should be an accounting and you should pay money And at volume 1, page 97, you can see what they asked for in the motion to enforce. At the conclusion, enter judgment in favor of the class against merit, including all amounts determined to be due and owing. So they want to use somehow bootstrap this judgment that was entered in 2008 into a judgment that they can enforce by simply a motion to enforce.
Okay.
If that's what they're trying to do, then they should be also bound by the dormancy statute. If that's how they're trying to use the statute, if they're trying to use this judgment as
But
basically
it
a
sounds
money
like you're
judgment.
arguing two
I'm sorry?
conflicting things.
Well, they're trying to, I'm saying this is what they're trying to do. If they're trying to do this, then they should be barred by a dormancy
Okay,
statute.
so I'm the district judge
Yes.
and I enter a judgment that approves the settlement agreement. The only way, there's no way to enforce that judgment is what you're saying. The only thing would be a breach of the settlement agreement?
Well, if the judgment had incorporated the whole embodiment, if it had been a consent decree, like a divorce consent decree, where everything agreed to by the parties becomes the judgment of the court, then they can enforce that,
Well, the court didn't dismiss the case.
which.
I mean,
Our court?
the trial court, originally, it didn't dismiss the case, it made a finding in the case.
Well,
Right?
the original judgment actually dismissed the claims that had been brought in 1998 against Oxy.
So it dismissed the claims because of the settlement agreement. So that was the deal. Okay.
That was
yeah,
basically it.
Okay.
But the problem is you're bound, and
I
all
get
of
what
us are
you're saying.
bound by the statute. And the dormancy statute by its own terms says except for certain specific exceptions.
So
Yeah.
are you saying, it seems to me that there's language in the district court's opinion that says all judgments expire after 7 years if you don't have an execution on them. Is that correct?
No, that's not correct. It cited the statute as saying it says any judgments. But all this court said, Judge Ambrosia, was that in this case, on these facts,
Well, the language was pretty broad. It says, all judgments.
well, he was quoting the statute, which says any judgments except for the ones that are, it starts off with, except for those accepted in subsection B,
So if I
Any
get a
judgment.
title order from a judge, it expires in 7 years because I
You don't
don't
have
have an
to,
execution on it?
I don't know. I don't think you would have to reach that issue because this is not a quiet title suit. There's no quiet title suit in which somebody is coming in and asking for $10 million,
We have to deal with the language of that order.
right?
And if we approve that, aren't we saying then, unless you get an execution on a judgment, it's gonna expire in 5 years or 2 years after that, after it's dormant, it's done. I mean, that's the language that you're having to defend, isn't it?
No, I don't view the district court's language or its order, its findings of fact as saying that every conceivable judgment in the world, including quiet title actions or deck actions, are barred. He is saying that in an action like this, where you have an approval of a class settlement and where the plaintiffs are seeking essentially a money collection from the defendant, that kind of an action is the classic kind barred by the Dormant Judgment Act.
We have cases where people are ordered to pay money
Yes.
periodically. And the cases also say that every month that 7-year period is extended,
Yes,
but it comes due. So how is that any different here when these payments are due under the contract that you have under the leases every month? So why isn't it 7 years after each particular month's payment?
well, because there's a huge difference between those cases and this case.
Explain it to me.
Well, in those cases, you have divorce cases that order somebody to pay monthly alimony
Well,
or
you've agreed to it and the court has approved
it's
and so you got an order, right?
well, no, you don't have an order in the judgment ordering compliance with that statute, with that agreement. All you have is now a private or separate settlement agreement, and that can be enforced by a breach of contract action.
Law says a judge has to approve these particular class action judgments, correct?
Yes, it's fair and equitable.
Mhm.
But that approval is not the same as a consent decree. We've got a lot of cases in here throughout America federal and state, that say just because you approve a class action settlement doesn't mean that all of the terms of the settlement have the effect of an order, a court order like a consent decree, forcing and allowing for a motion to enforce under those circumstances. Huge difference between a divorce decree that orders somebody to pay alimony for 20 years each month and a mere approval of a settlement. Their remedy now is to sue for breach of the settlement agreement when, well, it's actually the leases that give you the right to get paid every month. The settlement agreement here limits the scope of the deductions, they claim, and that's what they can and are suing for in the other case.
This has to have come up before. I mean, class actions end in settlement agree. I mean, that's
Yes.
how they end.
Yes.
Generally. So
Yes.
are there cases out there that specifically say you can't file an action to enforce that settlement agreement as it has to be a contract issue that you violated the settlement agreement? I mean, how have there been claims that have been made like the appellant makes here that have been accepted? And what's your best case that they're not?
Every case I'm aware of where somebody has a class action settlement that has some future term, the mechanism to enforce is to sue for breach of the settlement agreement, all right?
That may be a mechanism, but are there cases out there where the mechanism that was used here was used and supported in Kansas?
I don't think anybody in the United States has ever tried to do what they're trying to do,
Okay.
which is to merely take an approval of a settlement and treat that as an effective injunction.
Okay, so you say
Body.
there are no published cases out there that you are aware of?
I don't think so.
In Kansas, and what about elsewhere?
I don't think so,
Okay.
because nobody's ever tried to do what they tried to do.
Okay, all right.
Now, I just want to touch briefly on his suggestion that, oh, we don't know what how much is owed and all that stuff. Merritt started paying royalties in 2014. They waited 9 years to bring this action. Their own lawyer at the time, who's his partner, Mr. Seeley's partner, Mr. Stuckey, in support of this particular motion, filed an affidavit in which he said, you can, right on the face of the checks, you can see what the deductions are. In fact, you can see right on the face of the checks, and you can readily see it what it is. And he said that it was perfectly clear. That's at the record, volume 1, page 230. They said, well, we don't know about MMBTUs, and all you reported was MCF. He said directly that it's generally a close 1-to-1 correlation. So calculating deductions per MCF provides a close estimate of deductions.
So there's not a discoverability issue, you're saying? They could have seen it all along.
Oh, they unquestionably, that's what their lawyer in 2023 determined. Had he looked at it in 2014, or had Ms. Ryder, who was the class rep after all in the first settlement, simply looked at it, studied it, it doesn't take it's really fairly much arithmetic.
Mr. Seeley, I'm sorry, but you're going to have to stop it with the
So-
facial expressions and laughing and not appropriate.
Mr. Stuckey's affidavit demonstrates how easy and simple it is to see on the face of the deal in 2014 that there was clearly amounts at 3 to 9 times in the month of July to 2014, yet they waited 9 years to proceed. Even if there was some tolling, the statute doesn't allow tolling here anyway in this, a discovery rule tolling. It's not in the statute. They could have easily brought a renewal affidavit, a motion for reviver, and done anything else, but 9 more years passed. So even if there was some tolling of any sort, they've had 9 years, and they waited 9 years to bring
So
any
they'd
action.
be outside of a statute of limitations to bring an enforcement of the
Well,
settlement agreement action, according to that theory, right?
In the other case, in the Ryder case,
Mhm.
they conceded that 3 years of limitations passed, but to 2017, but not after 2017. And so that's what they've already conceded in the other case.
The other case.
But in my view, this case clearly falls within the statute. It's not within Judge Ambrosier's discretion to change the statute, to create exceptions for injunctions or for any other provision. The legislature chose not to create an exception for this kind of a matter. And
Counsel, you need to sum up.
I'm sorry.
All right,
Concluded.
you done?
Yes,
Okay, thank you.
thank you.
3 minutes, you've got it.
Thank you, Your Honor. First, I just want to clarify that we are pursuing this matter as an action for enforcement because we believe there is no statute of limitations on a motion to enforce a judgment that has continuing effect. Second, I want to just dispute counsel's suggestion that Judge Smith, Tom Smith, may rest in peace, just rubber stamped this thing. That's not true. He took his responsibilities under 60-2223 very seriously. He reviewed it carefully. He discussed it. It was discussed.
Well, that's not an issue though. It's
During the
whether he
settlement.
reviewed it. We have he said it was fair and everybody seems to agree it was fair and equitable.
Thank
That's
you,
not
Your
an
Honor.
issue. Okay.
Next, I'd like to just say there is a discoverability issue here.
Mhm.
And Mr. Stuckey's affidavit, Mr. Stuckey has 50 years of experience litigating against oil and gas companies in the Hugoton field in Kansas. And based on that experience, he was able to make an estimate only, of what he thought the deductions being taken were. But an ordinary farmer, rancher, royalty owner doesn't know that, and Merit doesn't provide the BTU content of its gas in a conversion factor so that you can convert MCFs to MMBTUs and determine whether they're violating the 15 cent per
How did the
MMBTU.
district court address that issue?
It did not.
Did it need to?
I think it did to the extent that it certainly relates to the tolling issue. If you can't determine it, you can't execute, you can't enforce. If you can't determine it, you can't put an amount on a writ of execution.
Counsel, your opponent says you are doing something unusual here, totally unique. Nobody in the United States has ever filed a lawsuit such as this.
No, Your Honor, that's incorrect. There have been motions to enforce settlement agreements filed in many states, and I'm sure in Kansas, we've not had to do this before because everyone's lived up to their obligations after the settlement. But in some instances, there have been irregularities and motions to enforce the settlement, motions to enforce the judgment have been filed to enforce the terms.
Are there reported cases and do you cite any of them in your?
I can't cite any now, Your Honor. I'm sorry.
And that wasn't addressed in your brief as far as you know?
No, Your Honor.
Okay, thank you.
Any other questions?
No, I don't have any.
Thank you, counsel.
Your Honor, I just like to close by saying that we believe this court should follow the example set by the 10th Circuit. Just as that court rejected Merit's attempt to deprive the class of the remedy available to them under Rule 23 and under the court's contempt power to enforce the judgment, so should this court refuse to strip them of the right to enforce the terms of the judgment that Merit has deliberately violated. The rulings of the district court should be reversed. The case should be remanded as more fully set forth in our opening brief. Thank you, Your Honor.
Thank you very much.
Counsel. Very interesting case. We'll take the matter under advisement and issue a written decision when it's done.
You'll get it when you get it.
Like those submissions regarding the status.
Oh, 10 days or so. Something that both, you can do it simultaneously.
Is there something more that we need besides the 10th Circuit opinion? You'll just need to tell us that you filed there was some sort of extension of,
Just something in a status of what's going on in federal.
Okay.
Something jointly filed as opposed.
Well, it doesn't matter.
Yeah,
We'd be happy
If
to
we could
work.
do it jointly, that would be
We can do a
fine.
joint speech.
Yeah, it just keeps us advised of what's going on. I'm not sure that
impacts.
it affects us, but we'd like to know what's going on.
We'll get together and file something joint.
All right.
Thank you, Your Honor.
Very
Thank
good,
you.
thank you. All right, our next case on the docket is 128-881 Sampat versus the Department of Children and Families and Joshua Stone.
Just showing up.
Council will enter their appearances for the appellant.
For the appellant, Dr. Craven Sampat, Poncolino Flores Jr.
And do you wish to reserve time for rebuttal?
I would like to reserve 3 minutes.
3 minutes, you've got it. And for the applicant,
Good morning, Your Honors. Mark Altenburn, General Counsel for the Kansas Department of Children and Family Vocational Rehab, and Joe Shaughnessy.
all right, thank you. You may proceed, counsel.
May it please the court. This case is one in which the district court, as the court is aware, denied or granted a motion for summary judgment, basically for two reasons. One, both of them related to the sufficiency of the evidence to support a prima facie case of discrimination. Applying the Beach decision from the Supreme Court, which in our view has really no application to the case at hand. The Beach case was a reduction in force case, and it was appealed after a trial to the court, where the court made specific findings of fact and conclusions of law, and was subject to a different standard of review than the case before the court today. Today, we're here to determine whether or not, as the court, I'm sure, knows, that the evidence that was presented on behalf of the plaintiff in this case, in the light most favorable to him, presented a prima facie case of discrimination. The court required us to show that the position from which my client was terminated was filled by a non-protected group member in order to establish a prima facie case. That is not the law. As pointed out in my brief and set forth in the 10th Circuit decision of Kendrick versus Penske, the court noted that there is a line of cases that says that that is one way in which a plaintiff can establish a prima facie case, but it is at best language that is dicta and not a requirement of the court.
But the Beach aircraft case uses the 4 elements, and one of those elements, I think it's the 4th element, says that was replaced with somebody that was not in protected. How is that the language was qualified for the position? That sort of thing.
And a non-protected group member,
Yeah.
yes. That is true. That is what Beach says. But that Beach also acknowledges that there are other ways through which a plaintiff can establish a prima facie case of discrimination. In this case, and the general rules with regard to these cases, starting with McDonnell Douglas and following through Burdine and Martin versus Nanny and the newborns and the other federal court decisions upon which this area of the law evolved, all suggest that and state that what we're really looking for in a prima facie case is whether or not you're a member of a protected class, whether you suffered adverse employment action, and whether or not the evidence, whatever your evidence be it replaced by another person or some other direct evidence, has a tendency to establish an inference of racial or other discrimination against the individual. And in this case, it is uncontroverted that my client's position was not filled until after what would have been the statute of limitations on his claim under the Kansas Act would have expired. That is, it was filled in August of 2022 when this case was had to be filed by late November of 2021.
What does that show us? What is that fact? What is the significance legally of that fact?
Well, what it demonstrates is the ability of an employer, and in this case, the state of Kansas, to bypass or engage in unlawful discrimination by simply waiting to fill a position until the time has expired for a plaintiff to pursue their claim. Then they fill the position and say, you lose because it wasn't filled during the time that you had to file.
Is there a burden to show that it was done with that intent?
No, I don't believe so.
We just are to infer it because of the facts that
We
there was a period of time that it wasn't filled?
We infer it because the position remained open and accepting of applications for the position continued.
Sometimes the state moves slowly.
That is very true. But we're only talking about an inference of discrimination. We're talking about the first step towards establishing the claim. This is just the first prong of a three-pronged test that the plaintiff would have to establish in order to show that he was the victim of unlawful discrimination. We're not talking about the ultimate burden at trial. This is supposed to be an easy step to determine whether or not there is some evidence to suggest that the plaintiff was discriminated against. And in this case, what we have is, and this goes to the issue of disqualification, which was the other issue that the court relied upon, the absence of any evidence to suggest that he had anything other than above standard or exemplary performance during his entire tenure from June of 2015 through December of 2019.
There was some question about that.
There is question about that. The question was Ms. Stone's affidavit and the other supervisor's affidavit that said he had poor performance. There was no documentation, no written documentation of oral counseling, no written documentation of any kind of disciplinary action or counseling, nothing in the record. And my client's testimony was that he hadn't been disciplined or talked to about any poor performance.
And
When
the-
this,
The first indication that he had, and you can correct me if I'm wrong, was the same year that he had a positive. Like earlier that year, he had had a positive review.
correct, in in January of 2019, the former director, Dr. George Stern, evaluated his performance as above standard or excellent in all areas. Within a month of that, Ms. Stone was hired and put him on a performance review, reviewed some cases of his, and he heard nothing back from that. Not that he was doing a good job, a bad job, or an average job. And so we are to infer at this stage of the proceeding that there was nothing lacking in his performance because of the evaluation that he had received within 30 days of that. And so when you get through the year and you come to December, and during that period of time, the same person who did a performance review of him changes the terms and conditions of his employment by assigning him different cases that he was assigned to than he was assigned to before, treating him differently than other doctors who were performing medical reviews. There's an inference that comes up of discrimination against him. And that's all we need to establish at the prima facie stage is an inference of discrimination. Then the employer has to come forward with their legitimate non-discriminatory reason, which would be the poor performance issue. That is a question of fact. That is in dispute. Even if we don't include Dr. Griffith's affidavit, which we believe should be included because under 6219, it was based upon her stated personal knowledge. She defined how she had personal knowledge of the facts that she made in the affidavit, where she testified and said that Dr. Stampat was treated differently than the other non-Asian, non-protected group doctors in the office.
Counsel, is there a question about the timeliness of your client's appeal?
No,
Everything's been done timely?
I don't believe was ever an issue raised about its timeliness. I believe the question, I'm not sure where that question might arise. It may arise in the issues with regard to the federal case that was.
Yeah, the federal case?
The federal case that was filed, that it was dismissed, and this case was commenced and served within the 6
Within the
months
time frame.
of, yes.
Very good.
But that raises the other issue, which would be I believe the third issue in this case, whether or not Judge Christopher rightfully dismissed those federal claims
And
as
whether
res
you timely
judicata.
appealed that.
Excuse me?
And whether you timely appealed that. That's where the time.
That's where the time
comes in.
question comes in.
Before we get into that, can I go back for a minute? Because this whole idea that the individual was replaced by a person outside the protected group, is that kind of unique, a unique rule in Kansas or? I mean, that I hadn't seen that before, but you know, I've been out of practice for quite a while, but I think what I hear you saying is the statute doesn't make this requirement. This is one case that says these are 4 things to look at. And when you say it's really more like dicta, what you're saying is these are 4 things that were considered in Beach, but these 4 things are not part of the statute. They're just things that the court is saying, these were things you could look at to make a determination that discrimination has taken place. Is that how I understand your argument?
That is absolutely correct.
Right, because this language doesn't appear anywhere in the statute.
That's
This is
correct.
just the court opining. But
this
this
is one
isn't a
way.
hard and fast rule.
Right.
Is what you're saying.
Correct.
Okay, I just
And-
want to make,
And that was further recognized in my argument with regard to the failure to inform of the performance issues was further recognized in another unpublished opinion that I discovered this week. Matisse versus the City of Stafford, Court of Appeals decision filed August 2nd, 2024.
and so you believe there's a factual issue because they never documented that his performance was poor. There's no documentation and you have an affidavit from somebody that says he was treated differently and his performance was good. So that creates the factual issue that should allow the case to go
At least to the next
past
step.
summary judgment at least.
Yes.
Okay, I just want to make sure I'm understanding this.
That is absolutely correct in terms of what we're contending in this case. Now, getting back to that race judicata issue for a moment.
The federal case.
The federal
Yes,
case,
I do want you to-
Judge Christopher raised that on her own, sua sponte, in terms of, I don't believe the state had indicated that they believed or agreed that there was race judicata applicable to those decisions or the
But the
decision.
issue is she made that decision well before this summary judgment decision, and the summary judgment motion didn't have anything to do with the dismissal of the federal claim.
Correct.
So and did you file a reply brief
I did not.
responding to that jurisdiction issue?
No, I did not.
Okay, thank you.
I just asserted it in I had no new argument to make other than what I had.
Oh, I'm
in
sorry.
my-
You asserted it in your
Opening brief.
appellate opening brief? Okay,
Yes,
I was
that it-
thinking that they had just raised it in their appellate brief, but okay.
Because under 6241, the dismissal, voluntary dismissal is not on the merits. It's by statute that it's not on the merits, and so it couldn't be res judicata or issue preclusion,
Okay.
which is what Judge Christopher found. And that was,
Right, but I think we're talking 2 different things. She said that was the reason she dismissed the federal claim. The
yes,
jurisdiction issue that I'm asking if you raised in your opening brief was because you didn't, that wasn't part of your notice to appeal. So your notice to appeal didn't include the dismissal of and was that just, because I think they talk about that, the appellee talks about that. Did you talk about that I don't have the briefs here to look.
that specific point about it not being raised in the notice of
Of appeal.
appeal, I don't believe was included in my opening brief. It was addressed, I believe, in the docketing statement, and it was reserved in the docketing statement. And
Okay. But they raised it in their brief.
yes,
Okay, and you didn't reply.
I did not reply.
Okay, thank you.
Thank you, Council.
Thank you.
You still have your rebuttal time.
Yeah. So will you answer that my same question for me? These 4 factors from breach, or it was that beach, not breach, beach, not breach. Is that hard and fast black letter law that those are the 4 things you have to have? Or was this just a court saying, these are 4 things that you could, I mean, if the court did say that, they pulled it out of thin air because it's not in the statute.
The Kansas Supreme Court in Beach, under facts like this one, where you're dealing with an individual who is terminated from a position. And it's important because these discrimination cases can have different types of facts that change the elements a bit.
Right.
That's why Beach is important, because it specifically addresses the facts in this case where somebody was terminated. And those 4 elements given by the Kansas Supreme Court, that is the prima facie cause of action in Kansas for termination cases under these two statutes. Now, the Kansas Supreme Court, if you were to look back, and I laid this out in my brief in an attempt to provide some understanding where that came from based on counsel's argument. They took these elements from a Kansas appellate court that utilized these same four elements in this type of cause of action. They took those elements from a federal court case, again, using the same facts as this case. So that's how it progressed. And in all three of those cases, it wasn't an either or. Are we going to use all four elements? Or are we going to use some of the elements? Counsel makes the argument in his brief that because the Beach Court used the word, you may prove a prima facie case by using these four elements, that somehow made the four elements optional.
How should we treat this precedent then? Is it binding upon us, or are these suggestions by the Supreme Court that if you have this, you've got a prima facie case? Well, how are we to deal with that?
The Beach,
Exclusive.
the Beach decision we submit is absolutely binding on this court. It's a Kansas Supreme Court case dealing with the facts of this case under these two statutes. So in that respect, these aren't optional elements. The court, there's nothing in this decision that makes these elements optional.
But
They're required.
in every case, these
In
four are-
cases under these two statutes
For termination.
or termination, which is distinct because not all employment discrimination cases
Right.
carry the same facts. Some you have a failure to hire, some you have a failure to promote, so there's different factors and they use different elements based upon what those are. This is also very specific to the Kansas statutes. Judge Christopher, for example, counsel didn't file a complaint with these two statutes. Judge Christopher, in addition to her sua sponte dismissing on the basis of res judicata, which we did not argue, by the way, also said, hey, let's see if you can file something under these facts.
Because I'm going to throw it out under this.
I'm
I'm going to give you an opportunity to
Yeah.
amend, to add.
Right. So
That's when they added the two statutory claims.
that's correct, pursuant to her suggestion.
Mhm.
So the Beach case is directly on point. And in that respect, it's a Kansas Supreme Court case. There's no cases out there that question it. There's no yellow flags. It's on point. Counsel's argument that these elements are optional, the four elements are element 1, 2, 3, and 4. I mean, that's how it's phrased. So all four are required. It is undisputed that Mr. Sampat or Dr. Sampat was not replaced by anybody. It wasn't just somebody from an
How
upper.
do you respond to Mr. Flory's argument, though, that, well, isn't that convenient? Because then an employer can avoid a discrimination case by just keeping the position open until the statute of limitations runs.
Well, it's a novel argument. It's an argument he didn't make in his brief. He's making it for a first
Okay.
time today.
Yeah.
It's an argument that I don't think makes a lot of sense. I can tell you as somebody who's worked at DCF for 6 years, if we have a position open that needs to be filled, we fill it. The facts of this case, as testified to by Joshana Stone and her supervisor in the affidavits, there was a period of time where all the files were reduced. There wasn't as much of a workload. So Dr. Sampat's primary argument is he had a reduced file number. And nobody else did,
Right.
although he
which
testified that
then
he hasn't,
made less money.
right, although, Although-
Wasn't it that he was given cases that actually were that had more information in them? And
Took more time.
took more time?
yes,
And that
he
wasn't
offered,
given given as many of the easy, in quotes, easy cases?
yes, he argues that he was given different kinds of files than the other consultants and fewer files than the other consultants. Of course, at his deposition, he testified he has no idea what any of the other consultants were receiving. So, which is one reason why the district court judge said, your testimony can't save this motion for summary judgment because you yourself admit you don't have any idea what anybody else was doing. And this goes to Dr. Griffith's affidavit and subsequent testimony because they attached the affidavit to the response to the motion for summary judgment, whereby she offers testimony about the files and the number and the types, although she doesn't provide any foundation as to where that information came from. And this is a motion for summary judgment. This isn't a motion to dismiss. So the evidentiary requirements are different. They have to submit evidence that is admissible, and we've put that in our brief, that is admissible at trial. So the court said, and we actually came back and the judge reopened discovery at that point to allow for us to depose the affiants. So I deposed Dr. Griffith, and her testimony I've placed in the brief. She testified she has no idea what she doesn't know what Dr. Sampat was doing. She didn't know what the other consultants were doing. She thinks she might have received that information from Dr. Sampat himself. And then we get text messages that basically confirm that. There's a conversation when two of them, Dr. Sampat reaches out, says, "Did you notice I'm getting fewer files? I'm getting different files." I mean, so Dr. Griffith stated, "I have no clue where any of this information is coming from." It's also important to know, counsel criticizes the affidavits of the DCF employees. No depositions were taken of them. Nothing was done with respect to their affidavits. They were left to sit there, even though the court reopened discovery on that. So
his claim is that he's being treated differently than other employees in his position because of the protected class, but he was able to present no evidence to avoid summary judgment that there was anybody treated better,
correct.
basically.
Correct. I mean, we're talking about the third and fourth elements of the prima facie case set forth by Beach. The third one is not replaced.
Is that fatal? Do we even need to get to this? To me, is crazy. That somebody's been replaced. That factor number 3,
Right.
which really seems very bizarre to me. But I mean, I see it could be it could be a factor, but a mandatory factor. But anyway, so is the fact that he wasn't able to show that he was being treated any differently, is that the game changer right there?
Well, I mean, the overarching argument of any discrimination case, right, is disparate treatment.
Right.
Every case you look at, federal court, state court, disparate treatment, that implies that he's being treated differently than others because of his race.
And the fact that he could not present any evidence, is that alone enough?
I would say it's alone enough in the sense that element 4 requires that he present some evidence, admissible evidence, that he was qualified for the job in light of testimony given by the defendants. Now,
well, isn't the heart of these claims that they have to show that the membership in the class made the difference?
yes, precisely.
That's the essence of what has to be done.
Precisely. That is precisely the point. Under these statutes, at the end of the day, when we cut through everything, the plaintiff has the burden of proof that he was terminated because of, in this case, his race and or age. He has provided zero evidence of that.
There's adverse action here. He was terminated. And you stipulate that he's a member of the
Oh, certainly.
class. So the only thing that you're concerning is that whether he was qualified for the position, was he qualified for the
He was
position?
qualified.
Are you stipulating that he was qualified?
No. One of our arguments, arguments 3 and 4, argument 4 is qualification. At the time he was terminated, he wasn't qualified for he was terminated because of job performance.
Well, that's a
So,
little bit of a stretch, isn't it? I mean, it's qualified, then that would be everybody. Why is that a separate factor? Because if you're terminating somebody for poor performance, then you've met factor 4. That can't be what factor 4 means.
well,
It means he was, when he got the position and held the position, he had the requisite training and experience to do the position.
sure.
Whether he did it properly or whether others were treated differently but doesn't this factor just mean I was qualified for the position and I was treated differently? I mean,
ultimately,
seems like a stretch to say qualified means you're not qualified if you're not doing the job well.
we can disagree on that, and that's fine. The point is, there's no evidence he was terminated due to his race or age. Dr. Sampat argues he was terminated. Therefore, it's because of race and age. He provided no evidence as to what was happening to anybody else. In fact, he admitted at his deposition, he doesn't know what any of the other consultants were doing. He doesn't know if any of the other consultants have been fired. He doesn't know anything about any of the other consultants. Dr. Griffith at her deposition agreed with that. She didn't know either.
Right. I'm not doubting that.
Yeah.
I'm just saying, is that enough? That he didn't present any evidence that he was treated any differently?
Well, if this court decides that he's made it past his prima facie, which means this court,
Well, what I'm saying is that that is absolutely the single most important thing that he's got to, if he doesn't have any evidence on that, he's out of it.
yes, because under the shifting process,
And do you even need to get to these other things is what
well, you
I'm
have
trying to
to
say.
because that comes first.
Okay, so you're saying Beach says you have to.
Beach said, yeah,
But if we say Beach doesn't say you have to, it's just,
right, the McDonnell Douglas shifting burden, the plaintiff has the burden of providing a prima facie case, evidence to support the 4 elements. We assert he doesn't get there.
okay.
But even if he does, then you have to get to the second point where we provided an argument that he was terminated for reasons other than race or age. Well, there is no evidence that he was terminated for race. The plaintiff himself can't even give evidence that he was terminated for race or age.
I'm going back to Beach again.
Sure.
It seems to me, when I read Beach, it says that if you have evidence of this, there's a presumption involved.
Mhm.
And if you don't have elements of all, you're not entitled to the presumption. Isn't that basically it?
Our position is the analysis ends with Beach. Beach lays out the 4 elements that the plaintiff has the burden of proving to start the whole analysis. And one of those necessary elements, he was replaced by somebody in the unprotected class. It's undisputed he wasn't. Now they're arguing that we did this purposefully to avoid the statute of limitations. There's zero evidence of that. That question wasn't even asked by anybody, including counsel for Dr. Sampat.
Was there evidence of, was he replaced
No.
by anybody?
By anybody. It remained vacant for over 2.5, almost 3 years.
What year was, I'm trying to find what year Beach was decided.
I've got it here, judges, 1993.
So
So
way
they
before our Supreme Court started into this.
I don't know if it's vacant to this day.
Statute and only the statute, and we're not gonna read anything into the statute that isn't in the statute. I mean, they've certainly held that a lot since 1993. But anyway, as you can tell, I'm personally, I have some problems with Beach being used as this irrebuttable presumption, an exclusive list and an irrebuttable presumption. So
Even if it wasn't,
I'm laying that card on the table.
isn't there the shifting burden? He has to show
Yes.
some evidence
Right.
that he lost the position due to his membership in the class.
Yes, and he has to,
It's a fundamental thing.
yes, and he has to provide evidence
And what
at this
evidence is there in this
stage.
record
There's none.
that the court had
There's none.
before.
At his deposition, he testified he was being treated differently because he was getting bigger files and fewer files. But that begs the question, fewer than whom?
Right.
Bigger than who? And when I asked him that question, he doesn't know. He admitted, I have no idea what any of the other consultants were doing. Dr. Griffith, his one witness, said the same thing. She has no idea what Dr. Sampat was doing. So there's no admissible evidence before this court. And again, this is motion for summary judgment. This isn't motion to dismiss. Plaintiff needs to provide admissible evidence. And there simply isn't any. And if I could quickly address the Christopher,
Uh-huh.
he didn't appeal that.
Right.
It's not in the notice of appeal.
Right.
And there's no reference to it. The notice of appeal is very specific. It deals with Judge Beffert's order only. Doesn't mention anything having to do with Judge Christopher. There's no general language about.
And you raised to this in your.
Yes, yes. So we submit, this court doesn't have jurisdiction to consider that order. Thank you.
Mhm, thank you.
Mr. Flores?
To answer the question, on the record, in the record on appeal at page 189 is where the affidavit of Ms. Stone references that the position was filled in August of 2022.
Oh, okay, it was.
And to address counsel's argument that my argument here today was raised for the first time here about the position,
That
not
they could
filling the
delay
position
and-
would be delayed. That's on page 26 of my brief where I
Okay.
directly raise and assert that that's an argument before this court. With regard to Dr. Griffin's testimony, Dr. Griffin, in the text messages that were referenced in a part of the record on appeal, without suggestion by Dr. Sampat in the course of their discussions, stated, I remember before you left that they weren't sending you certain types of cases, supportive of disparity in treatment between Dr. Sampat and other physicians, that she remembered without prompting by Dr. Sampat. And these are questions that I'm not asking the court to accept as gospel truth, but that raise material issues of fact as to whether or not my client should have been allowed to proceed forward with his claim of discrimination. To say that there was no evidence of any disparate treatment, while Dr. Sampat could not identify a specific doctor who was treated differently, he did say that his terms and conditions, and it's in the brief and it's in the record on appeal, were changed. They were different than under Joshana Stone than they were before she took over. And that's, those facts are set forth in my brief beginning on page 9, where she reduced the number of cases that he was allowed to work on, where she affected his ability to earn the same wages, assigned him large charts for review, and even gave one example of where he did on October 29th of 2019, get assigned one of these quick review cases, and then he went to open it in his queue and it disappeared. It went to somebody else. Even not even allow him to return to work early when he got back from vacation in November of 19. All of these things led up to this termination. Beach does not apply here. Beach was a RIF case. It wasn't a straight termination case. Termination cases, like failure to hire cases, have a different standard than a reduction in force case.
Because in a RIF case, it would be very pertinent if they'd replace the person.
Yes.
Because they're saying, I'm letting you go because we don't have any more work. And then if I come back in, I'm undercutting that idea if I come back in and hire somebody in the position.
Correct.
So that's what makes, that's your argument that
The
that's
beach
what-
is, and, but for.
that factor is specific to a RIF case.
Yes.
Okay.
And that.
At least, maybe all of them, but at least that one.
At least that one, yes. I don't know if I could go all the way with you there, but yeah, I
Okay.
would like to. I would like to.
You'll go with me one step at
Yes.
least.
And so, thank you.
Thank you. Break or keep
Don't mind.
Okay.
We're gonna take a break of about 10 minutes now. We'll be back in, I'll tell you what, at 10:25.
So the attorney for Collins is here, right? Okay, all right.
We'll be at recess for about a few minutes, till 10:25. Please be seated. Council, this has happened before, but we have been advised that in the next case, 129-088, Collins versus the Kansas Department of Revenue. That's your case, correct?
Yes.
Counsel Marissa Jones is quite ill and is unable to attend today. And so she is submitting her argument on the brief. So, counsel, if you want to enter your appearance, we will certainly entertain your argument today, but I'm not going to grant you any rebuttal. Yeah, do it for the first time and we'll call it good.
May it please the court, Tyler Childress for the appellant, Micah Collins.
All right, thank you.
Let's cut to the chase.
Sure.
You know, this is my old bailiwick, DUIs. I heard hundreds of them over the court, probably thousands. So in this case, the police officer pretty upfront says, I didn't base the stop. I didn't base my suspicion of him being under the influence on the 3 times he didn't signal. He focused it on the smell of alcohol from coming within the vehicle when he got up to the car, and his testimony that he almost hit a car as he pulled over. Is that correct?
I think on the issue of the turn signal, whether it was 2 or 3 times, he very clearly never signaled twice. The final time he signaled, I think, as he's stopped at the stop sign,
I
which
watched
is,
the video, and it looked to me like 3 times, but it doesn't matter because the officer I mean, most officers would say, yeah, he didn't signal and then he did that, but
Right.
this officer said, no, that didn't make me suspicious.
and I would agree that that was his basis. We take issue with almost hitting a parked car. When you watch the video, Mr. Collins clearly in one continuous motion pulls to the side of the road appropriately, as Judge Goddard's noted in his memorandum of opinion. He said that while almost hitting a car, he did pull over appropriately. The testimony of swerving to miss the parked car, that's not borne
Well,
out by
or
the video.
almost hit is what the judge said
Correct.
after viewing the video.
Correct.
So on that fact, that's a factual determination by the judge, right? We don't get to replace, or do we look at the video and make our own conclusion about whether he almost hit the car?
I think when you have a mixed standard like this, you do have to look at the evidence that was presented and determine, is there substantial competent evidence? My argument would be the video does not bear out what the testimony was, is not consistent with what the judge's ruling was. But I will say on the trial court level, I disagree with Department of Revenue that the statement by the trial court that the bloodshot eyes and the admission to alcohol was only going to probable cause. In the memorandum decision, it very clearly states bloodshot eyes, admits to drinking, and then Judge Goddard says clearly the officer had sufficient reason to require the plaintiff to undergo field sobriety testing, indicating that the trial court did consider 2 pieces of information that Officer Dowd did not have when he made the decision to initiate the DUI investigation. I would also
What
add
2 pieces of information didn't he have?
bloodshot eyes and admission to drinking. Those 2 only occur after Mr. Collins is taken out of the vehicle.
Okay.
Didn't he
so-
say that he saw the blood, sorry.
No, that's okay.
Didn't he say he saw the bloodshot eyes as he was asking him to stop out when he approached or was at the window? And as he was coming out or asked him to come out, that's when he saw it?
So there is in the preliminary or in the trial transcript, there's a question asked by Mr. Bath. Did you see the bloodshot eyes after he got out of the vehicle? And the answer is yes. He already made the decision to extend the stop as he's approaching the vehicle. And so I think even if we take the view of he makes that observation when he's asking Mr. Collins to step out of the vehicle, the decision has already been made at that point that he's conducting a DUI investigation. I think it's also important when we're looking at the case law we've cited to, all of those cases, even ones cited by the Department of Revenue, the suspect or the driver they smell of alcohol. It's attributed to the driver, and the driver admits to drinking some quantity of alcohol. Here, Mr. Collins has just told the officer that he's picked up two of his friends from the bar. Officer Dowd testified at the trial that he did not have information that Mr. Collins himself was in the bar, only that the two friends were in the bar.
Okay, so he steps up to the car. He says, I smell, I think he said pretty strong odor coming from within the car. So are you saying you don't think he had the right to ask the gentleman to step out of the car so he could determine if the smell was coming from him?
Under these facts with two other passengers, we do not believe so.
You don't think he could even ask him to step out to try to determine if it was just the passengers he's smelling? He should just let them go on down the road.
Correct, Judge. Under these facts, we do not believe that there's a basis to pull that driver out of the vehicle, with the basis of the stop being improper use of turn signals.
So whenever I'm in a car and the police smell the odor of alcohol in the car, and there are several people in the car, I get a pass.
I don't think it's you get a pass. I think it's the law clearly states that the smell of alcohol, admission to drinking, and sometimes even other facts, when you look at the Mosier case, those facts alone do not give you the basis to extend the stop and turn it into a DUI. Any law-abiding citizen can have a beer when they're out for dinner, when they're at an event, can get in their vehicle, and are not necessarily committing the crime of DUI. And so that smell alone does not give them the basis to pull them out, because
Okay, so if it was only him in the car and he smelled the odor when he came up to, a strong odor when he came up to the window, that alone is not enough to get him out of the car.
if he is sitting alone in the vehicle and the officer can smell alcohol and he admits to drinking.
No, I just smell of
Okay.
alcohol. Let's not have any admission yet. Officer walks up, strong smell of alcohol, driver's sitting there. He doesn't have any right to question him further about that or prolong the stop any longer.
Yes, if that's the only piece of information, I think the case law is clear that that cannot be used alone
Okay.
to extend into a DUI stop.
Counsel, I have a different question than what the other two judges. Does it make any difference that this is a driver's license? I hear a lot of these questions, and your answers certainly might be pertinent to a prosecution for driving under the influence, but aren't we dealing with the question of reasonableness here when you're dealing with a driver's license review?
I think the standard, both in a criminal proceeding as well as the driver's license proceeding, is very similar. I understand that the effect is different. I understand the burden is different. Here at the trial, it was our burden to demonstrate that the agency action should not have been made. But when we're talking about the Fourth Amendment and the application of whether there can be government action, I don't believe under those circumstances there should be a distinction recognized by this court. I understand that procedurally it's different. We have more obligation than we would in a criminal trial where we didn't have the burden in that criminal trial. It was up to the prosecutor, the state, to demonstrate that their actions were lawful. But I don't think the decision of whether there's a Fourth Amendment violation and whether it was reasonable, I don't believe there's a meaningful distinction on that issue here.
An exercise of an officer's discretion in a driver's license case is held to the same standard as an exercise of discretion in a criminal prosecution. Is that your position?
My position is that when you're analyzing under the Fourth Amendment and whether there was reasonable suspicion, yes, that is the case.
You take it immediately to constitutional grounds, although there's no chance of incarceration here.
I do, Judge. It's still an impediment on the freedom of movement of Mr. Collins by extending this stop. It keeps him detained there.
Fundamental difference in what's at stake, isn't it?
Well, his right to be free from a search or a seizure, I think, is very fundamental no matter what the government action is and no matter what the type of proceeding is.
You're saying this is a search and seizure?
Well, he was seized when he stopped, and the officer is supposed to advance that stop. The purpose of the stop here was not using turn signal. unless he's got reasonable suspicion of of another crime, he's got to be working towards that aim, whether issuing a warning or whether issuing some type of citation to Mr. Collins. By pulling Mr. Collins out of the vehicle and initiating standardized field sobriety testing for a DUI, he's no longer addressing the purpose of the stop. And he's, at that point, he has.
Actually, you know what the purpose of the stop is until he starts investigating. Isn't that a fluid thing oftentimes because it's based upon the facts that he discovers?
Well, the basis of the investigation is he observed Mr. Collins not use his turn signal and pulls him over.
So he's limited to that.
Unless he develops additional information that develops reasonable suspicion of some other type of crime.
Then that's where the judge's questions about the odor of alcohol come in. So all these things develop during the course of an investigation.
That's correct.
It's all fluid. It's not, your argument is you're stuck. That the officer can't do anything after that.
My argument is if the only information he develops while investigating the known turn signal and issuing that citation is the smell of alcohol alone, and there is no other information, then it can't graduate into a DUI investigation. I'm not saying that when he smells alcohol, as he's still working on the
And
citation.
what prohibits him from going into it?
Well,
Is it unreasonable then for him to further his investigation, asking him to step out and to see if the odor of alcohol is coming from him? That was unreasonable?
case law has made it clear that you don't develop reasonable suspicion of DUI based on the smell and admission of alcohol alone.
And is that Mosier?
Mosier, as well as
The key there is alone, isn't it?
well, in Chambers, Judge, I agree with you that you take everything into consideration. You consider all the pieces of information. It is fluid as it develops, but the issue is it has to develop where the officer's continuing to gather additional information. And at the time he decides to do the DUI investigation, which is when he pulls Mr. Collins out of the vehicle, he at that point in time has to have sufficient information under the law that shows reasonable suspicion that Mr. Collins has or is committing the offense of DUI.
And that's in a prosecution. But we're not in a prosecution here. We're in a driver's license suspension case, correct?
Yes, Judge.
And the standard's not different.
Not on a constitutional issue like this, because Mr. Collins is seized. So that's the government action. And in order for the government to do that and not contravene the Constitution, regardless of what proceeding the state is in, they have to have reasonable suspicion to continue the detention for the DUI, which they did not have here.
Can you tell me what the other case is you're relying on besides Mosier?
Chambers, Judge. And
I don't have your brief in front of me.
I first cited on page 8, Judge. It's
What's the site on that?
2017 Westlaw.
Okay, so it's not a published case
It's
either.
unpublished Court of Appeals.
Okay, so you want us to base our decision on 2 unpublished opinions by this court, which you're not even really supposed to cite in your brief. But, and one panel doesn't, I mean, we're not bound by 2 unpublished decisions. Like if these were decisions by the Kansas Supreme Court, then we would be
Sure.
bound, but we're not bound by Mosier or Chambers in any way, are we? And
Well-
if you don't have any Supreme Court cases or published cases that say that, do you?
No, because no court in Kansas has ultimately decided that issue. Pullman is cited by the Department of Revenue. They explicitly say they're not going to consider or make a decision on does the smell of alcohol alone. And so if this court's view is the smell of alcohol alone allows a DUI investigation to be initiated, that's reasonable suspicion, that's your decision.
Mhm,
It would
right.
be helpful for practitioners if we had that published opinion, because it does clarify, obviously this is a line that we're kind of dancing around,
Right.
and it would be very clarifying for practitioners in that area. But I would agree, no Kansas court has definitively made that decision yet. Why Pullman is different from this case is a husband and a wife are driving motorcycles. The wife is pulled over. There's a smell of alcohol from the man himself He admits to drinking alcohol, but there's also the added element of interference. Why that's different here and why I don't think you should reach the same conclusion as the Department of Revenue is it's very clear that he actively was trying to interrupt that investigation over an extended period of time. He pulls, I think they described one car length in front of his wife. He's told repeatedly to either leave or go over to a neighboring parking lot. He's belligerent. And that is what developed into the reasonable suspicion because his behavior was not consistent with somebody that's pulled over and listening to
Here we
officer.
have the alcohol and we have the testimony that he came close to hitting the parked car. Now, whether that was swerving or whatever, I watched the video. It looks like he comes pretty close. I don't know that I could say I mean, I don't think I could substitute my decision for the district court who said it looked like he came pretty close and the officer who said he came pretty close. I mean, I don't think I would bring the officer up on perjury charges for that. I mean, it was a close enough call looking at the video of that. And the judge made that factual determination. So that's two factors you have, smell of odor in the car and the almost hitting the parked car when he pulled over.
And the important part for us is the odor is not attributable to the driver specifically.
Right.
Other cases.
And he doesn't have
has
a
been.
right to figure out if that odor is attributed to the driver.
Under these facts, no, not to
Okay.
detain him further.
So do you disagree that the state has an interest in protecting motorists on the road from somebody that is too impaired to drive?
I would agree that there is an interest and that's why it's balanced with when there's a warrantless seizure. The courts have made it clear that an officer can develop reasonable suspicion to conduct that investigation. So I don't disagree that there's competing interests here. Mr. Collins' ability to go about his way, the state to make sure everybody is safe and driving appropriately. And the line that we've decided to use as the balancing test is, does the officer have enough information to develop that reasonable suspicion to extend that stop into a DUI investigation? So yes, I agree, but there's also the interest of Mr. Collins to go on his way as well.
Very good. Any other questions?
I don't have any
Thank you,
more.
counsel.
Thank
Thank
you.
you very much.
You may withdraw.
Thank you, Judge.
We'll take up our next case.
We don't have any more this
Not
morning.
this morning.
Oh, that's
Would you
right.
like to jump
What's that?
ahead?
I beg your pardon. Well,
If I were on the bench, I'd say, is anybody here for the next hearing yet?
No, I don't think so.
unless there's anything further, we are adjourned until this afternoon at 1:30.
Okay.
Guys?
Research. Yeah. Let's have the research attorneys back.